Welcome to the In-Rem Podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, good morning, everybody. Welcome to the show. Today, our topic is, do unique real estate deals require unique closing strategies? I'm Andy Fowler. I'm here with Sean St. Clair. If you're new to the show, give us a like, subscribe to our channel on Facebook as well as YouTube so we can continue providing you content. We appreciate all of your support. With that, Sean, give us a legal update.
So today I want to talk about joint venture agreements, and specifically what are joint venture agreements and when are they to be used. So basically what a joint venture agreement is an agreement between multiple parties to engage in some type of business or real estate transaction and to provide that certain parties may bear certain percentages of the expenses. They may perform certain services with respect to the business or the venture. And then it provides how they're going to share profits, how they're going to share cash flow, for example, if it's a ongoing business or a cash flowing real estate investment. And it then talks about how that's going to be handled. It's going to talk about how expenses are repaid, when they're repaid. It'll even have provisions in there potentially on interest on those expenses or some type of markup on the repayment of those expenses. And I've found that when it's used in situations where parties don't want to basically form a limited liability company, do an operating agreement, put that in place, but they want to still work together on a particular transaction or on a particular business venture, but they want some type of agreement in place on how that's going to be arranged. So basically what a joint venture agreement in essence creates is a partnership. So there's no formality, no formal state involvement where you formed a entity with the state, but instead you've agreed informally to share in the profits, losses, expenses of whatever venture that you're doing. In real estate, I see a joint venture agreement used in a couple of contexts. One is we have two limited liability companies, and those companies or their owners want to do business together, and they want to jointly purchase property. And so they're going to basically both come on title to the property, but then behind the scenes, there's more to it than just 50-50 ownership of the real estate. There's certain expenses going to be paid by one party, certain expenses by the other, certain work is going to be performed by one party and maybe not the other. And then maybe even profits going to be split different than maybe how title to the real estate is held. Obviously, if you're going to do a different percentage of and profit split, but you're going to take title 50-50, something like that, then you probably want to talk to a CPA and figure out, the potential tax ramifications of that. But nevertheless, you can set up exactly who's going to do what, who's responsible for what when it comes to the real estate. The other is where one party, is going to be on title by themselves, but somebody else is going to be behind the scenes participating in the transaction. And in that case, and expecting, some share of the profits or to participate in the venture with respect to that real estate or that piece of property. And in that case, there's certain things that can be done to protect the party that's not on title. One common would be to record a memorandum of the joint venture so that they know, hey, somebody else is out there. So when this property is sold, profits need to be, apportioned accordingly, or payments need to be paid and disbursements paid according to the party's joint venture agreement. And the joint venture agreements that I draft always have provisions in there saying, hey, the parties are going to come together at the time that the property is sold and put together escrow instructions that are delivered to the title company. And they both have to sign off on those escrow instructions to say, okay, this person gets repaid for this expense and this amount. And here's how the profits then allocated. And that way the title company has those instructions and the parties are protected, even though maybe one party is on title. Obviously, once again, if one party is going to be on title, but then there's an arrangement kind of behind the scenes on, participation in the real estate and in the venture as it relates to the real estate, a CPA should be consulted to figure out, those potential tax ramifications. But that's when a joint venture agreement is used, and it's not a bad method of engaging in business for two parties to engage in business together, or multiple parties to engage in business without having to go through the entire formality of forming an LLC and putting operating agreements in place and that type of thing.
Well, I've always liked it because it's a nice one-off or maybe a couple deals, because everybody thinks starting an entity is easy, and it frankly is, but nobody thinks about the back end of it dissolving an entity and the work that goes into that. And if you're a real estate investor and you do a lot of your own stuff and you've got your entity and that works well, but you've identified maybe some other players in the space that you also want to maybe do a deal with here or there, it makes it for a lot easier because you can do a one-off and not have to, at the end of it, dissolve any sort of entity. When the deal's done, the deal's done. The money goes to their LLC and your money goes to your LLC, and you can move on to the next deal without, worrying about doing all the formalities of dissolving what would have been a business.
Well, and that's exactly right. I mean, the joint venture agreement provides that, especially if it relates to just one piece of real estate, that the joint venture and the purpose of the venture is terminated upon the sale of the real property. And so, like you said, there's less paperwork, less administrative headache by just simply putting a joint venture agreement in place.
Right. All right, Sean, thank you for that legal update. So today, again, our discussion is we're talking about unique real estate deals that require unique closing strategies. So with that, we wanted to discuss that topic with some folks within the industry, within the title industry. So with us today, we have guests Cari Sparks and Cynthia Turas with us today to discuss those issues. Cari and Cynthia are both with WFG National Title Insurance Company. And we appreciate, do we have them here?
Yeah. Right now we don't have the video feed on. But Cari, are you there?
I'm here. Absolutely. Let's see if the camera will come on. Can you hear me?
We can hear you. Yeah.
Okay. We'll have to, I guess, go with it. My camera says that it should be on, but good morning, Andy and Sean. Cindy and I are here to help you guys answer some questions today. We're excited and feel very privileged to be a part of the podcast.
Yeah, we really appreciate you being on, Cari. Just a introduction. Cari is the Assistant Vice President of Sales Strategist and Sales Executive for WFG National Title Insurance Company, and Cynthia Tura, the Assistant Vice President, Branch Manager of WFG Title. I'll throw this question out to either or both of you, but tell us about WFG Title.
Sure. Thank you for asking. We are just thrilled to be a part of this company. It's a fairly young company. We're 12, 13 years old, based out of Oregon, and made up with a lot of people that have come from some of the larger underwriters across the country that we all are familiar with, and taking the cultures of all those different places with their tools and resources that a national underwriter can bring to the table, and being able to offer it into the Arizona marketplace for the last several years. We're about 7 offices strong right now and growing throughout the entire state of Arizona in a really good, methodical way. But as a sales rep, I have to tell you that being able to have highly qualified escrow staff and title resources is imperative for me to do my job. So to be a part of this corporate culture and a part of this company is quite an amazing thing for me in my career. WFG stands for Williamson Financial Group, and so we have a couple other subsidiaries that are out there to assist real estate agents and loan officers in improving their scope of business with some very unique products in the marketplace that I'm privileged to coach and train on every single day.
Tell us about some of the unique marketing strategies that WFG offers to its investor clients.
Sure. We have some things that are pretty static inside of the industry, but I think what it comes down to is the level of expertise that the sales rep has to each one of those individual products. So I've coached and trained on products like Break Your Broker for close to a decade, but really right now, I think focusing on the swing in the marketplace of being able to sit side by side with real estate agents and loan officers to train them on a product, which is a national platform called Altos. And locally, we hear a lot about the Cromford Report, and I love Tina Tambour and the Cromford Report and Michael Orr. But this is a solid tool that costs the agents and loan officers, as well as the investors that you're talking to, absolutely nothing. But they get to be able to really pull the market apart down to even a zip code, should they so choose, rather than just looking at the valley as like Maricopa County or a city such as Scottsdale or Phoenix. You can literally take it right down to a set area. And it's really amazing how broad the scope is in the swings in values and inventory, and whether it's price per square foot when you just go a few miles within the valley. But then another product that is unique to us exclusively is called Fetch. And this really takes the traditional real estate agent, loan officer, or the investor and puts them in head-to-head with those national platforms that might be using artificial intelligence to stir up opportunities for purchase or sale or investment. But it really is a very important piece of what I do every day. And as a matter of fact, I just got done teaching 7-8 real estate agents about how to incorporate artificial intelligence into their business plan and be able to do it today. So the things that I teach are very much something that can be applied whether you're a realtor, loan officer, investor, something that you could do to make a difference in your business today. And so Fetch is very strong in that space for me. And it's amazing the information that is available that's bought and sold over and over again as it relates to data. And we all know that we're being tracked. So this is something where you're able to capitalize on the fact that that is out there.
Cari and Cynthia, let's talk about our topic today. And we, as a podcast for real estate investors, we're working with individuals and entities that are doing a lot of real estate transactions, but a lot of those transactions are unique, not your conventional type of transactions that we're all used to seeing when we just go buy our house and close at the closing table. And with those unique transactions, we know that investors, if they want to have a smooth closing, need to prepare for having a strategy in place and knowing what's at play to do that. So we want to go through some of what we think are unique transactions and talk about what you guys see and how you recommend being prepared for that. Want to start out and talking about transactions where the signers are not here in Arizona, or not, maybe even perhaps not even in the United States. We see more and more international purchasers. Talk to about the issues at play in there, what you're doing to solve that, and discuss RON, R-O-N, how it works and when it can be used.
Okay, yes, RON is definitely a new tool that we've been using the last couple of years, where either we have a FERPA seller who's out of the country, or even like you said, either a buyer or seller that's out of the country or out of the state of Arizona. So they're not able to meet with a traditional notary. They have to be able to utilize they have to have a computer that has a camera on it, obviously like a Zoom call, And they also have to provide a couple different forms of identification. Obviously, the traditional ID, state ID, or passport in some cases. Some states do not allow that. Arizona does. Or a green card if they have that. And then they also have to go through another it's called a knowledge base authentication. I can't say the word. With the Ron Notary themselves. And then there are some cases where the seller or the buyer does not have a state ID, and then there's cases where they'll use a credible witness, which in that case, the credible witness would have to be very well known to the seller or the buyer, the signer, and be able to answer questions to the notary that would prove their knowledge of that signer. So it's a wonderful tool. Like I said, if you're unable to have the traditional notary, and it saves time and money in that case as well. A lot of lenders, however, do not approve of this type signing at this case. There are more and more that are jumping on board. That's the struggle that we still have with the lenders. And some of the lenders have their own e-signing type systems as well.
Hi, Cari. Hi, Cynthia. How are you two doing?
Hi.
Doing great today, Sean.
So I wanted to follow up on that, on the RON or remote online notary question. And I appreciate, the explanation that, hey, while this is good, there's still some lenders who, write their rules. And we always say that, there's what the law provides and, what the parties to a transaction will actually approve, such as a lender. And they're not always the same thing, which is unfortunate. But to follow up on that, I know that prior to the invention of Ron here in Arizona, I've had a number of clients, and I saw it a lot, especially in the short sale days, where the seller is out of the country, and they may be going to medical school somewhere, or they may just be vacationing, or whatever the case may be, but they're not located here in the United States, and they're not in Canada, for example. They're, some other location. And I've worked with them in, officially notarizing documents, because when you're out of the country, you have to go to a local notary, but then you have to go to the embassy and obtain an apostille, right?
Yeah.
And the embassy could be 2, 3, 4 hours away. And then you have to make an appointment. And so it's a process to actually, validly notarize a document in some countries outside the United States. Does Ron resolve that issue? Assuming you have a lender, you don't have a lender who's saying no, that we won't approve Ron, but, let's just say it's a cash transaction. Would Ron resolve that issue?
Absolutely. And that's where I have had the most experience with sellers, buyers that are out of the country that have not been able to make that appointment with the embassy, or not able to locate an attorney to take care of that, and then getting the documents back to us also in a timely manner. So yes, Ron has been a tremendous savior as far as the time and the expense. I mean, there is still an expense for the Ron notaries, but it's nowhere near what we've seen in the past with the attorneys in the embassy and what they.
Yeah, I remember in the short sale days where, you had lender imposed deadlines. Once again, the lender, is involved in the transaction and writing their own rules, and you have lender imposed deadlines. And I remember working with sellers to run around trying to figure out, how to get this signed. And then, like you said, get the documents back over. And I want to jump ahead a little bit, and then we'll go back and talk about some other transactions. But, with the market changing the way it is, the anticipation of short sales, does WFG have experience in handling short sale transactions? And if so, what are some unique things that we see in a short sale transaction that we might not see in just your traditional real estate transaction?
It's interesting that you bring that up, Sean, because just this morning I was talking with a broker and he was talking about the rise. Although so small it is, truly right now we are seeing an uptick in it. So partnering with a company and partnering with an escrow unit that has a long history is incredibly important to be able to make sure it's facilitated properly. And Cindy can take it from there.
I mean, yes, a lot of us here at WFG in the Arizona division have extensive experience in the short sale because we've been around as long, But as Cari was saying, we have not seen the influx of short sales as yet, but we have been told by many sources that it is just probably around the corner with what's happened in the last couple of years with people losing their jobs, even though they may have the equity now. It may be something that we'll see. So yes, the idea that we may not have a short sale unit thus far. I mean, I think, if it gets to that point, we probably will go that route. But at this point, we have the experience. And that is obviously a plus once we get into what's required from the short sale as far as the lenders, the lien holders, and getting the approvals and the whole routine and the requirements that are needed.
So take us through, some of our listeners, while they're experienced investors, they've never been through a downturn. Andy and I have both been through a downturn. So we're familiar with the short sale transaction. I'm sure, like you said, you guys are familiar with that as well. But talk to us about what it looks like on a short sale and all the moving parts that you have to deal with that make a short sale transaction unique.
Okay, so typically when you have a short sale experience, you have a seller that is behind in their payments. And so we work directly with the listing agent long before she has a buyer to work out different settlement statements for the lien holder. And then when the lien holder and the buyer and the seller has to also provide, as you're probably very aware, the different documentation that the lien holder is going to require to even begin the process of approving a short sale. And then they go and the listing agent will put it out on the market and get a buyer. And then, of course, we work it from there. As far as we have to work directly with the lien holder and the listing agent. The listing agent is very key to the whole process. As far as getting either back when we were doing so many of them, a lot of the lien holders had their own platforms that we would upload the settlement statements to. I haven't been seeing those as of late. The few that I've done in the last couple of years, I've worked directly with the listing agent. And then once we get an approval from the lien holder, then it is closed basically the same way a traditional escrow would close, except for at the end, we have to make sure that the lien holder is satisfied and we have the promise of a release.
And included, so you need lien holder approval. So if you have a first position loan, you need approval from that lender, right? And then if you have a second position loan, you need an approval from that lender. Another lien holder that's out there that I've found is always difficult is your HOA. How does the HOA work in a short sale transaction?
Well, the HOA, the short sales I've had in the past, the HOA unfortunately would not be a part of that process. We would not, they don't, at least the ones that we did in the past, the HOA was not entitled to anything. And I'm not sure, because they can lien the property, but what we had in the past was those past due liens or fees and assessments were forgiven. And then the HOA had to go directly to the seller with a judgment, a personal judgment against them. But it would be released for the property for the closing.
Oh, so the HOA would agree to release their assessment lien against the real estate in order to allow the transaction to close?
Right. Mhm.
Well, that's good. That's positive.
Whether or not that changes, I'm not sure, but at that
Right.
time, that's what happened. The HOA their lien was forgiven.
Cari, and Cindy, I think a lot of people now who didn't go through it take for granted this term short sale. 10 plus years ago in the last recession, this idea of a short sale wasn't even done. And everybody's like, well, it's going to have to get done. So we went through probably what amounted to a year to year and a half of just coming up with systems on how to do this correctly. And then everybody got pretty good at it. The realtors got pretty good. The title companies got pretty good. The lenders got on board and it started to be more seamless. And just when it hit its apex, the economy turned and everything was done. Do you think it sounds like, given like with lawyers like Sean and I who have been through this before, title companies like you all, real estate agents who have done this, the 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 ability to begin doing these transactions is there and shouldn't really be a backlog like it was the last time. Do you get the sense in the ones that you've done that the lenders are at a place where they could pick this up if they needed to and be able to process these kind of like they
Yes,
did it?
I do feel the agents that had the experience, I know that they would be able to jump right back in, and obviously escrow and title would have to adapt as well. And like I said earlier, a lot of us are still around. So it would be, the larger lien holders, yes, I feel that they could just jump right back into it and it would just be the same process. I have done a handful of short sales in the last 5 years, not as many, and they were all basically treated the same way that they were back when we were doing them as a regular transaction, a seamless transaction. So
I remember back in the day very clearly that there were agents who didn't touch anything but a short sale for years on end. And some of the feedback that I would get from them is the sensitivity that they developed to the situation with their clients, and it just felt a little different just because of the sensitivity that somebody was going to be leaving the property that they may have raised their children in or have so many memories in. And those people are still out there and still in the marketplace. And I'm sure that they would come forward and step back into that space again. But that ability to have some sympathy, empathy in the situation, we always have to be the unbiased party to the transaction, but to handle everything with kid gloves and make sure that we treat somebody just in the highest level of respect. And I'm sure those people will come back, like I said. I know many of them that are still out there that are bracing themselves, readying themselves to be able to step into this very sensitive situation and lend a hand that is very experienced. I believe the short sale designation is still out there for real estate agents. So if they want to get into that space to go and get themselves educated at a higher level in that particular niche, but I feel very confident that WFG is here to help and lend that hand and be there as this or any other type of transaction comes through.
It certainly seems like, given the recession, the last recession, that put the industry in a much better place holistically to be able to handle that potential type situation. We'll just wait to see whether that becomes an issue or not, but it certainly seems like the industry is prepared to handle that. Let's talk about probate. A lot of investors like to find deals in probate. A family's either in a place because somebody's passed away and they're looking to move the property to pay beneficiaries, and there are deals to be had in probate. What kind of title issues are you all typically running into in trying to close a deal where the property's found in probate?
title issues, I mean, not unless they had liens, you know, the they, appoint a personal representative and basically we work with them. The listing agent works with them as well.
So is
and
that kind of an initial problem that you see on the front end, is kind of an authority issue, given that the person on title has died?
Once we have that, the proper documentation from the court that, they've appointed a certain personal rep, usually that's done. Listing agents do reach out to us when they are taking a listing with such a situation and ask for what is required. And we help them along the way if necessary. Otherwise, we start working with that personal representative right out the gate. And if there's any liens, it's just handled the same way. I haven't really seen extensive problems with title in that area unless there are, quite a few. But it's handled basically the same as a traditional escrow in my eyes.
Gotcha.
So when we're talking about probate, you mentioned that, there's certain documentation from the court that's necessary. What documentation is it that you're looking to see from the court to allow you to, close that transaction?
The letters of appointment of personal representative. That's what we're looking for.
And what if the property, can those letters be replaced by, say, an affidavit of some sort at times?
An affidavit,
Like an affidavit of succession or something like that?
that would be up to the title department to make that decision. I have, typically, it's not my call. I fall on the title, chief title officer to make that call. You're saying if the personal representative is not able to act, that there would be an affidavit, is that what you think?
Well, in today's market, we probably don't see them as often, but we might, at some future time. But basically, if the property is less than 100,000 and the owner has been deceased for over a 6-month period, and there's some other requirements that normally are pretty easy to meet, you can do an affidavit of succession to real property, which
Sure.
basically, is signed by the beneficiaries or whoever's entitled to the property. So there is no personal representative. They just fill out this affidavit, state all the relevant facts. They submit it to the probate court and the probate registrar reviews it, make sure everything's in order, stamps it, and then that original document is either recorded or provided to, a title company like WFG,
Sure.
and it records. Have you seen or been able to close, simply with an affidavit, without
I haven't
doing
seen
a
anything
letter?
like that in the state of Arizona, but definitely in Illinois. I've also been in Illinois. Yes, I mean,
Yeah.
it's just a different way. If it's a small claims affidavit, is that basically what you're saying?
Yeah, that's exactly right. Each state calls it something else. There's
Yeah.
a bunch of these documents out there that some states, refer to as like a small estate affidavit or
Right.
things like
right.
that. But yeah, that's essentially what it is. It's similar to that. But not every state has it. In fact, we had a probate attorney on from Florida, and we were asking him about, an affidavit of succession or a small estate affidavit. He's like, yeah, we don't have that. It's either
Right.
formal or informal probate, basically. So which both would provide the letters that you were talking about.
Right.
Let's talk about properties held by a trust. What makes a transaction involving a trust unique? What type of disclosures need to be made? What documents does the title company need to review in order to close that transaction?
So we need the trust agreement or the certification of trust that discloses who the trustees are and if there's a successor trustee, if there's been a death. And then they also have to disclose the beneficiaries of the trust. Once we've had that reviewed, we move forward.
And then where do on the disclosure of beneficiaries, why do you need that information? Why would a title company in Arizona need to know who the beneficiaries of a trust are?
The beneficiaries then would have rights to that property as well. So if there's been any death or succession in that trust agreement, then yes, they'd be able to claim the property. So that is why a beneficiary is needing to be disclosed on that document.
And do they also need to be disclosed on the warranty deed?
The warranty deed, exactly. Mhm.
So it becomes part of the public record,
Yes,
whoever
it
the
does.
beneficiaries of that trust are is,
Yeah.
out there in the public domain.
Yes, it does. And not
What
all
about-
trustees are very willing to get that information, and we tell them, obviously. And most of the time, I'm seeing that the trustees are the beneficiaries until there's a death, and unless the trust is a different type.
Right. Normally under your family trust, the parties who created the trust, which have different names sometimes, grantor, settlers, they're the initial trustees. Normally they'll be the primary beneficiaries.
Correct.
And so that's pretty straightforward. Where it gets complicated, right, is if they pass away and now you have these other beneficiaries out there, who are claiming an ownership. Let's just say hypothetically, sticking with that, let's say that the original trustees who created the trust, they pass away, and now you have, let's say, 3 beneficiaries, their 3 children, and the property held in the trust is being sold. Who receives the money from escrow? Who can receive the money from escrow?
The trust. Their bank account has to be in the name of the trust. We cannot disperse funds to anybody but the trust.
So
Yeah.
even if the beneficiaries came forward and said, "Hey, I'm a 1/3 beneficiary of this trust," write 1/3 of the proceeds check to me, and the trustee signs off on it, it still has to go to the trust.
It has to go to the trust.
Let's talk about limited liability companies. Obviously, working with real estate investors, that an LLC is typically in place somewhere. I want to ask about initially properties in escrow that are currently held by the LLC. So it's transferring from the LLC. What kind of documents should the real estate investor be prepared or need to show to get this deal done?
Articles of organization and the operating agreement.
How
Yes.
often do they get to that stage and not have either, or have said they formed an LLC but
Well,
are
we
just
have to
starting the
have,
process?
I'm sorry, we have to have the articles of organization to make sure that it's a valid LLC. That would be filed with the corporate commission of that state. And then if there's not an operating agreement, we would go by the LLC or articles and have either the member managers or both sign an affidavit that one or more have powers to sign on behalf of the LLC.
What about for properties where the buyer is the LLC? Do you need any additional
The only
documentation?
thing we are really looking for is the articles of organization, once again, just to make sure it's a valid LLC. Other than that, no, we don't need anything further.
For an Arizona property, can an out-of-state, does title have an issue with an out-of-state LLC purchasing the Arizona property?
Nope. Once again, just to make sure we have a valid articles of organization. No.
And that LLC, title doesn't even require that they be domesticated in Arizona. They
Not at
can
all.
be operating outside of Arizona and just hold real estate here without being registered with our corporation commission.
No.
So let's turn to property subject to judgment liens. I know this is a topic of import because of recent changes in the law on recorded judgments. But what's your process in dealing with judgments that are recorded against the property?
Well, first, we ask for the seller or the buyer to fill out an identity statement, and that way we can check to make sure that belongs to the party in question. If it's not, it doesn't disclose enough information, then we go to the creditor. We go to the attorney to ask whether or not our party in question is the one on the judgment. And we may or may not get a payoff statement, or we'll get a letter from them stating that it does not belong to the party in our transaction.
How has the new homestead law impacted the way you guys or WFG operates? Has that created some complications on
To
the
this date, I
transaction?
have not really had anything further than like the same procedure that I was stating earlier. Whether or not it will in the next few years, probably will change. But at this point, I have not seen any.
So one of the things, and I know it's obviously subject to the language of the contract, but most contracts, the standard contract being used in Arizona provides that if the buyer cancels within the inspection period, that they receive a return of their earnest money, right? If they properly say, hey, we're canceling, and they comply with the terms of the contract, they receive their earnest money back. We've come across, a lot of our clients, they're Arizona based, but they're doing transactions throughout the country. We've come across other states and title companies in other states that have similar provisions in their contracts. And then when the buyer goes and says, okay, I'm going to cancel during the inspection period and I want my earnest money back, they say, oh, well, we need now a separate writing and authorization from the seller to release the funds. I've not come across that in Arizona, but it seems to be kind of a trend, outside of Arizona. And I don't know if it's, what's kind of fueling that. What's WFG's position on that? Is it a situation where, assuming the contract language allows for it, they'll refund the money, or is it, requiring a separate writing from the seller authorizing the release of the funds?
Well, if it's during the inspection period, and they provide a Benzer stating that they are rejecting the property, no, we have no issues with that. If it's due to a loan denial, there's certain things that they cannot cancel and get their money back if they didn't have the funds to close. There's certain language in the contract. Now, if there is a situation, I just had one where the buyer decided to cancel outside of the inspection period, and there became a dispute. So we had to. What we do is ask them for mutual cancellation, and if there is a dispute, then it is up to manager approval. But we, based upon the contract, we review the contract and return the funds, and then the buyer seller have the right to mediation, have the right to file a small claims with the other party.
Well, and that makes sense. I mean, if it's outside of the inspection period and there's a dispute, or even makes sense if for some reason the seller is going to try to, raise an issue and dispute it in the inspection period, where the title company, plays it safe and says, no, we want those mutual cancellations. But it's good to know that at least here in Arizona, our title companies, including WFG, are following the terms of the contract. Because what's happening in the other states is the seller just, they're not disputing it. They're just don't want to cooperate. They're hard to track down. They're hard to connect with. They're just say, I don't want to do any more with this, and they don't sign anything. And then all of a sudden the earnest money is just sitting there indefinitely, which I would think from a title company perspective, I would not want the earnest money just there, dangling out there and nothing being done with it because some seller can't be tracked down or is unwilling to cooperate. But you'd be surprised. We're seeing it more and more. And so, you have 5 $10,000 worth of earnest money just sitting there that the buyer can't receive and is out simply because the title company is saying, no, we're not comfortable, even though it was a cancellation in the inspection. We want everybody to be on board and to sign off on that. So I'm glad, we're practicing here in Arizona and we don't have those issues.
Reading the contract, right?
Yeah, exactly. It's like, read the contract. What are you doing?
Want to ask you about assignment fees and what kind of documentation do you need? And do you need documentation for assignment fees and other fees on a settlement statement?
Yes, the assignment, we would actually need the addendum to the contract, the assignment addendum. And that's, it discloses the assignment fee right then, and we put that, and that's what we show on the settlement statement. Now, I've had situations where the assignment also states that the assignee would agree to pay certain fees, such as the HOA fees. And so then that was fully disclosed on that assignment, on that addendum. So,
On our last show, we talked with a title representative out of Michigan, and she brought up an interesting point on wholesale transactions and where there's what they call a daisy chain, right? There's a lot of assignees, and the purchase price goes up exponentially. Yet the title insurance policy is based upon the original contract
yes, it is.
versus the actual amount that's being paid for the property. How's WFG dealing with that? Have you seen like assignees that are, down the daisy chain, the last one, the end buyer? Have you seen them come and, agree or want to purchase, additional title insurance to match
Yes.
the actual amount that they're paying for the property?
Yes, I have. And by the end buyer, or if the assignees have agreed to pay for that additional premium, yes, the end buyer would be responsible to pay the difference. But the seller, the seller actually, is only obligated to pay for the first sales price. Mm-hmm.
Right, because that's what it provides in the contract. So you've seen though, and that's good to know. You've seen though in assignments where maybe the assignee states, "Oh, I understand that you're not going to have a full insurance unless I step up to the plate and pay the difference in cost between the premium or the policy amounts for the original purchase versus your amount," and they actually step up and pay that?
That's where, yes, I've had a couple situations where the assignees have agreed to pay so that the premium is the actual end price for the property. Not often though, but a few occasions I have seen that. Otherwise, we only issue for the amount of the initial contract.
And is that something that the assignee picks up on, or is that something that you would discuss with the assignee and say, "Hey, look, your purchase price is, $200, but the original contract was for $150. Do you want to up your title insurance to the $200 mark?"
I did that myself. Yes, I asked it was the end buyer that agreed to pay the difference. They wanted the policy to match the amount that they actually purchased the property for.
Good to know.
Let's talk about double escrows. When and why have you seen them? When and why are they used, and what kind of complications are you all seeing in getting them
I
closed?
think I had discussed this with you earlier, but I'm not really fond of double escrows unless they have to be fully disclosed. All parties have to be aware that there's a second transaction happening at the same time. If that's okay, and management is okay with that, there's been different title companies that will not do these type transactions at all. So I've always just stuck with, if they're fully disclosed and everybody's aware, I have no problems with them at all.
So on double escrows, so those are disfavored by WFG clearly. and probably a lot of title companies
Right.
because of the issues that come up. And it, you know, it used to be that you could take the funds from the second escrow and apply them to the first escrow and close, and you would do basically simultaneous closings. That's not the case anymore, is it?
No, that's the only situation that I've run into a problem with that is that you can't take and transfer the funds from one transaction to the other.
So the buyer in the original escrow, and then the turned seller in the second escrow, that party has to be able then to, using its own resources or a loan or some means, they have to be able to actually fund that first escrow and close it, and
Yeah.
then turn around and close the second escrow. Is that
Yeah.
correct?
And that is where you would probably have a problem with a lot of buyers, sellers, that they're trying to use the same funds. And so I know that that has been the problem in the past, and that's why they're frowned upon.
And are you seeing that the buyers are either bringing the cash to the table themselves, or that they're using transactional funding to close that first escrow?
Like I said before, I have not done too very many myself, and the buyer has brought their own funds to the table.
Okay.
Want to ask you about some creative financing strategies. We're seeing a lot of different strategies employed right now with creative finance, but I want to list out a couple and kind of hear from you what you think the complications are in getting those deal closed. So let's start with wraps. What are you seeing, and what kind of complications are you running into with wraps?
Well, the only problem with wraps is that you have to understand how to do them for one, and I do. I've done several. Um, again, the risk value of having that lien holder become aware of the conveyance, and that's in the deed of trust that there is a clause in there that they could call the loan. So all parties have to be aware of that. We also, of course, have them. They have to be serviced by a title company that does account servicing. Um, And also the insurance policy. There is a problem with the insurance policy because you can't have two insurance policies. So typically, um, the seller would like to keep theirs in force, but they can't because they can't have two policies. And so therefore, the lien holder can become aware of that because of that case. If the insurance policy all of a sudden is not in. I mean, you keep both. Obviously, the seller's name has to still appear on the policy, as well as the new buyers, but that is pretty obvious that there's something that's happened with the property. There's been something, a change in the ownership of the property. So those are the risk values, for wraps. I'm not fond of them, to be honest with you. I would never do one myself because of that very case. That my initial loan, the underlying loan could be called, or become due in full. Other than that, if the parties are working well together and they're paying their loan on time, because the sellers, the new buyer has to pay their loan usually 10 days prior to the original due date of the underlying loan. So everybody has to work together. And if that doesn't, happen, then yes, you'll have problems. Then that seller
Sure.
will all of a sudden have to pay their loan again, pay their mortgage again.
Sure. What about the agreements for sale or land installment contracts?
And again, I haven't done those since I was in Illinois. We do have the agreement for sales out here as well. The only good thing is that they don't have ownership to the property until they sell. They have interest in the property, but they don't have true ownership until they paid that lien. So the agreement for sale has been satisfied.
One last one. This, you don't see this a lot, but it seems like when you see it, it's a major problem. But an investor buys up some land, and there's a nice little home on it. And they think it's going to be a great deal, and the home is a manufactured home.
Mm-hmm.
So issues dealing with buying real estate with a manufactured home, mobile home that is affixed or not affixed, or they don't even know or think to ask? What kind of issues do you run into
Well,
with?
if it's fixed, there is no issue. It becomes a traditional escrow. If it's not affixed, and we have a couple of them right now in escrow, and if there's a lien on the property, you're not going to get the titles from the lien holder until that loan is paid in full. And now I have a situation where the new lender is not agreeing to that because they wanted a fixed now, and that's just not going to happen. So there's a problem. This loan might, this escrow may cancel because if the buyer's not able to obtain financing from a lender that will approve that. Other than that, there shouldn't be really any issues if we have a system in place where we use a service that either fixes the property or transfers the titles to the new owner after closing.
So on the transaction that you mentioned before, where the mobile home's not affixed, but it's sitting there on the real estate, and it's going to be included with the real estate. So you're saying that the actual mobile home itself, not the real estate, but the home itself has a lien against it. There's a
Right.
lender out there. Is that correct?
That is correct. Mhm.
So, and then from there, the lender who's going to provide the funding for the buyer's purchase of the property, they don't want to just secure their loan by land. They want to secure their loan by land with a home on it, right? Is that correct?
Mhm.
So that's interesting. So in order, obviously, to affix it, you have to pay off that loan because that's a requirement. It can't be have a lien against it, and then you have to obtain a release from the either Department of Transportation or D&B or something along those lines.
Right.
So what's the solution? Is there one?
There may not be a solution with the current mortgage company that is not allowing it. The new buyer will either have to locate there are lenders out there that will do this, but they're very few. So that is, we probably will have a cancellation just because of that, unless we can help them with locating another mortgage company.
What if they found, I'm just thinking here, what if they found a transactional funding lender who, basically
There you go.
takes
That's
the
what
deed
we're
of trust
probably.
against the property,
Mhm.
as collateral, and then pays off that,
Yeah.
manufactured home lien, and then, works with the seller to secure it. And then they're just paid at escrow with, whatever the principal plus whatever amount that they've agreed to take as, compensation for that or interest, to close that.
Yes, and I believe that would probably be the only way that we could
Yeah.
actually go through with this closing, because we will get the titles from. I've already, spoken with a lien holder that holds the titles, and they gave me the timeline. It's 20 days after the loan is paid in full. They'll have the titles to us, and then we'll affix the property, and then everything will be um, the way it's supposed to be as far as a normal transaction, because the land is definitely worth more than the mobile itself. So
Yeah.
this is the traditional lenders are having an issue. They're the ones that are not as their underwriters are not as keen with the idea. So,
The whole conversation about manufactured housing has been increasing substantially over the last couple of years. Just a few years ago, some of my investors that I've worked with started flipping mobile homes. And so that opened up another dimension to park models versus non-park models and getting into a space that we weren't really used to having those conversations with investors about. It's become more and more popular now, the purchase of the park itself by investors. So there's a lot of conversation around manufactured housing. And I think we're the only title company that's a part of the Arizona Mobile Home Association. And so we're proud of that, to be able to work in that space. and take on those unusual circumstances and work through them with the owners and as well as the investors. But it's going to be very interesting to watch that market segment as it changes over time. Price of housing becomes more unaffordable for certain people, and see what happens within those parks, especially those active adult lifestyle parks where people are more on fixed incomes, and what happens with removing sometimes chattel from the parks, the unfixed. And so it's actually a very interesting conversation to have, and see where it goes in the next couple of years.
Well, I know as an attorney, where I've most often seen this problem in the past is when the parties attempted to do a transaction without using a title company and obtaining title insurance. That's what they did, and they sold the property, and they only got the real estate. They didn't get the manufactured home that was still personal property as part of it. So, a lesson to the listener: use a title company. Well, Cari and Cynthia, thank you so much for being on the program today. We really appreciate it. Tell us and our listeners where they can connect with you, the two of you, as well as WFG Title.
You can find Cindy and I and our team on our website, but also if somebody is interested in learning more about the products and services I talked about at the beginning of our conversation, just Cari Sparks and give me a call at 602-715-5704 or shoot me an email at csparks@wfgtitle.com. And I'm here to help and just really be a guide to people that are investing, if you're a realtor yourself or anyone who is in the mortgage industry with so many tools. You touched on a lot of topics today, everything from probate to, just many things of information that we have available to help and guide people and create the opportunities there. And then Cindy, how does someone get a hold of you?
My phone number is 480-385-3560, or email me at cturas, Turas, at wfgtitles.com. Love to work with you.
All right. Well, thank you so much, the two of you, for being on the show, and look forward to doing it again. You guys have a nice day.
Thank you very much.
All right, everybody. With that is our show today. Be with us next week as we talk about the Investor's Guide to Language in Lending Instruments. We're going to have a guest, Augie Panev. Should be a great show. Look forward to seeing you guys next week.
Have a good day, everyone.